Welcome to all of you to the first of a series of events that we're organizing here at Rhodes House on technology and society. Our topic for today is cybersecurity, combating cyber attacks across borders. And I was just reflecting on how this is an area of such intense importance to our world, and yet is something that certainly when I was a student, and I think this is probably true for quite a number of people in this Zoom room, it wasn't even on our horizon. So, tells you something about how global challenges facing humanity change and evolve, and we have to change and evolve and adapt and respond to them. We're delighted to have a very distinguished and international panel that's joining us today. Really appreciate their being a part of this. And we also have a wonderful audience that consists of Rhodes Scholar alumni going back to the 1960s. We also have some Schmidt Science Fellows and other members of the Oxford community. And so to all of you, a very, very warm welcome. Thank you for joining us. We do look forward to your questions and comments. And I'm going to turn the proceedings over to our moderator. He is a 2018 Rhodes Scholar from New Jersey in the Rhodes Scholar nomenclature, New Jersey and St. John's College, Christopher Durso. And I do have to just give a shout out to Chris because he just submitted his DPhil on this very topic on cybersecurity. And so we're very, very proud of him. Chris, congratulations, and delighted that you will be introducing the panel and moderating this conversation. So over to you, Chris.
Thank you so much for the warm welcome, Elizabeth. And it's really such a pleasure and honor to be here moderating this panel. As Elizabeth mentioned, I've spent the last 3 years thinking about these questions. So it's really exciting to be surrounded by a panel of folks who have spent their careers working in this area as well. It's funny when you create a panel and an event like this, you often have your list of people who you hope to get and you think, there's no way these people are going to say yes. And there's no way that all 4 of them are going to say yes. And I'm so happy that all 4 of them did say yes and are here with us today. And I'm sure, as many of you know, you can't go by a day or even a week without seeing a substantial cyber attack on the news. And increasingly, this has posed challenges to critical infrastructure and even to human health and safety. There was a case back in, I believe it was September 2020, where a ransomware attack against a hospital led to the loss of human life tragically, as a patient had to be diverted to another hospital and passed away due to the delay in treatment. These are incredibly important topics and questions to discuss and not easy to answer, but I'm very happy that we have this panel to help shed light based on their varied and international experiences. So joining us first, I'll go through each of their biographies before going into the discussion, is John Demers, who became Assistant Attorney General for National Security on February 22nd, 2018. In that capacity, he leads the Department of Justice's efforts to combat national security-related cybercrime, terrorism, and espionage, to enforce export control and sanctions laws, and to use the authorities of the Foreign Intelligence Surveillance Act, and to conduct national security reviews of foreign investments. Prior to joining the department, John was Vice President and Assistant General Counsel at the Boeing Company, where he held several senior positions, including in Boeing Defense, Space, and Security, and as lead lawyer and head of intergovernmental affairs for Boeing International. From 2006 to 2009, John served on the first leadership team of the National Security Division, first as Senior Counsel to the Assistant Attorney General, and then as Deputy Assistant Attorney General for the Office of Law and Policy. In addition, he has served in the Office of Legal Counsel and the Office of Deputy Attorney General. From 2010 to 2017, he taught national security law as an adjunct professor at the Georgetown University Law Center. John worked in private practice in Boston and clerked for Associate Justice Antonin Scalia of the U.S. Supreme Court and Judge Diarmaid Scanlon of the U.S. Court of Appeals for the Ninth Circuit. He graduated from Harvard Law School and the College of the Holy Cross. We are also joined by Fernanda Domingos, who has been a Brazilian federal prosecutor since 1998 and fighting cybercrime since 2007. She belongs to an advisory group on cybercrime and is coordinator of the Criminal Chamber at the Federal Prosecution Service and Cybercrime Working Group coordinator at the Sao Paulo unit and also the Human Rights Office Sao Paulo unit. She has a law degree from the University of Sao Paulo from 1994, and she holds specialist titles from the School of the Public Ministry of the state of Sao Paulo and has trained prosecutors at the School of the Public Ministry as well. She is currently pursuing a Master's 2 degree on transnational law at the Faculty of Law, Political Science, and Management at the University of Strasbourg. We're also joined by Shemin Keitner, Maritimes and New College 1996, so a fellow Rhodes alum. She is the Alfred and Hannah Fromm Professor of International Law at UC Hastings Law in San Francisco. She previously served as the 27th Counselor on International Law in the Legal Advisor's Office at the US Department of State. Among other publications, she has co-authored Cybercrime versus Cyber War, Paradigms for Addressing Malicious Cyber Activity, Foreign Election Interference, and International Law, and Attribution by Indictment. For the past 3 years, she has convened a colloquium at UC Hastings on democracy, technology, and security. Other recent projects include submitting an amicus brief to the Ninth Circuit Court of Appeals in WhatsApp versus NSO group and testifying before the Senate Judiciary Committee on Foreign Sovereign Immunity. She lives in the Bay Area with her husband, 3 children, and 2 rescue dogs. And last but certainly not least is Tara Wheeler, who is Cyber Project Fellow at the Belfer Center for Science and International Affairs at Harvard University's Kennedy School of Government. She is an International Security Fellow at New America, leading a new international cybersecurity capacity building project with the Hewlett Foundation's Cyber Initiative and a US-UK Fulbright Scholar in cybersecurity for the 2020-2021 year. She is an Electronic Frontier Foundation Advisory Board member, an inaugural contributing cybersecurity expert for the Washington Post, the Brookings Institution's contributing cybersecurity editor, and a foreign policy contributor on cyber warfare. She has appeared on Bloomberg Asia on US-China trade and cybersecurity, and she is the author of the best-selling Women in Tech, Take Your Career to the Next Level with Practical Advice and Inspiring Stories. She's an information security researcher, political scientist in the area of international conflict, author, and poker player. She has been head of offensive security and technical data privacy at Splunk and senior director of engineering and principal security advocate at Semantic Website Security. She has led projects at Microsoft Game Studio and architected systems at encrypted mobile communications firm Silent Circle. She has spoken on information security at the European Union, the Malaysian Securities Commission for Foreign Policy, the OECD, and FTC at universities such as Stanford, American, West Point, and Oxford, and multiple governmental and industry conferences. So if you're intimidated by this panel, you're not alone, but I'm very excited to hear what they have to say. So to start off the discussion, I'd like to hear each of your thoughts on what is the greatest cyber threat we're facing today. And John, I'll start with you.
Sure. Well, thanks, Chris. Thanks for the introductions. Great to be on this panel with such a great group, and just thanks to everyone for listening in and to this important conversation. So now I'm a little bit one-sided on this in the sense that as head of the National Security Division, my responsibility is for cyber threats that arise from nation-state activity. The way we're organized at the Department of Justice, the Criminal Division is responsible for the non-sort of government-related criminal activity of actors around the world. So I think that in the long run, so now this may be a bias, but I think that the greatest threat that we have actually, perhaps by marrying up these two groups, is to say it is this somewhat unholy alliance that has developed recently, not recently, over the past years, between the criminal hackers and their government sponsors / safe harborers. It is something that's reflected in a number of the indictments that we've brought over the years. It comes from both sides. Sometimes it's government officers who are moonlighting on the side as criminal hackers, using their tradecraft and their tools to just supplement their salary. But I think actually the most dangerous part are criminal hackers who are provided safe harbor by the governments in the countries where they're operating in exchange for being on call to those governments, for those governments to use them for intelligence activity. We have indicted cases that involve that kind of activity. Out of all 4 of the big nation state hacking sort of governments, China, Russia, Iran, and North Korea. Although probably, I'd put Russia first if we were talking about where most of that activity is coming from. But all 4 of those countries, unfortunately, have engaged in this practice. And, it's very dangerous for a number of reasons we can talk about. Actually, most manifested, I think, recently in the Colonial Pipeline hack, which you can also get to. But a great example of the governments around the world being always concerned, certainly here in the US, about intrusions into critical infrastructure, but focused more on what the nation states are doing to prepare themselves to use those tools in case of significant conflict with other nation states. And the moderating influence on nation states is the fear of the deterrent fear that someone's then going to use it against you, right? It's a little bit like nuclear deterrence. Criminal groups don't have that fear, right? They're not responsible for anybody's infrastructure. And so what you have is a criminal group operating in a country that is allowing them to do their criminal hacking because they can benefit them in other ways. And they're now going after the most significant parts of the civilian critical infrastructure here in the US. So that's my opening bid for most threatening sort of cyber risk of today.
So Tara, what are your thoughts on what is the greatest cyber threat we're facing at the moment? Would you agree?
I strongly agree that there is an unholy alliance, as John just put it, between criminal hackers inside countries that shelter them and permit them to operate at will. And I also agree strongly that we are in a situation where we're not quite sure internationally how to disincentivize this behavior. It's very difficult to figure it out. Individual countries indicting and prosecuting hackers in other countries, it's a response. But one of the challenges we perpetually have, I think, in my industry is making sure people understand that computers are not magic. We joke that computers are sand that we tricked into thinking. But one of the biggest challenges that I face on an everyday basis is just making sure that we don't draw artificial lines between cybersecurity and cyber attacks and acts of war or espionage that we would think of in a traditional or conventional sense. One of the hardest things I do is explain to people that yes, you can have kinetic acts of war that are committed partially in cyberspace. And SolarWinds, for instance, was an act of espionage, not an act of war. And yet we've got people who don't understand how computers work, who think that they're different, magical, strange, outre, arcane, somehow different than normal weapons, who it's very difficult to explain and use understandable words as to why it is that things that happen in cyberspace are real and that we already have rules for how we deal with them. I'm sure that John would agree with me on this one. I'm going to just say that because I'm going to pretend that you're going to agree with me on this one, that we already have names for the crimes that get committed in cyberspace. When someone steals someone's retirement funds, there's a name for that. It doesn't have to be fancied up with a cyber crime to attach to it. We already have a name. It's called fraud. When a foreign country attacks the water supply of a civilian population in another country, we already have a name for that. It's an act of war. It's not somehow different or somehow in Narnia because it happened in cyberspace. So the hardest challenge I think we're having right now is as people come to grips with Colonial Pipeline and JBS and the different kinds of hacks that we're seeing that target critical infrastructure, I think the hardest thing in my industry is to make sure that as this new realization is dawning in the world, that this is real and it's really happening, that we don't start to rapidly create new rules and a new regulatory climate around cyberspace simply because it's happening on a computer. We already have names for the things people do to each other, for the things that nation states do to each other. They're called crimes or acts of war, fraud, harm, abuse of a public office, whatever these things are. The kinds of crimes that are committed by foreign militaries against the United States, the United States' civilian populations, we already know what to call those things. We already have rules for them, and we need to stay firmly situated in the fact that just because it's happening on a computer doesn't make it somehow not as real. Fair?
So Shimen, now I want to bring you into this discussion since you have spent your career thinking about these types of international rules and laws. So I'm curious to hear your thoughts in response to Tara's comments.
No, again, delighted to be here. Thanks so much, Christopher, for convening the panel. I think that, to sort of move the conversation forward, because, John, I think, highlighted the problematic relationship between nation states and non-state actors in this space. And Tara reminded us that this space is not purely virtual and that we have grappled with similar issues in different contexts before. When I was thinking about your initial question on, sort of what is the greatest threat, it struck me that we can sort of subdivide threats, right, into threats to our physical environment and threats to our information environment. And physical environment, again, just to be sort of very broad brushstroke, for me would include all of those, 16 critical infrastructure sectors. So financial services, even if they're not tangible, when you're reading your bank account statement on your computer screen, it certainly represents something tangible, which, as Tara said, might be your retirement savings. Honestly, those I think are our maybe biggest short-term threats, and they're the ones that John and his colleagues and Fernanda and her colleagues are trying to handle with legal tools every day, and that Tara is trying to convince people to take seriously and put up the right defensive measures. I'm long-term most worried about the threats to our information environment, because the rules there are not as well established. There are certainly efforts through something called the Oxford process and other venues to try to figure out what rules should apply. As the other speakers well know, defining rules is very difficult, because unlike maybe in some of the traditional crime areas, free speech becomes a really important issue. You mentioned the Electronic Frontier Foundation that Tara has advises. Other groups are extremely attuned to these issues, which is so important. And yet, and again, just to maybe be a little parochial and look at the United States for a moment, although this is happening in countries all over the world, the erosion of our democratic institutions that I think flows quite directly from manipulation of our information environment, to my mind, poses the greatest long-term threat to the survival not only of our democracy, but not to put too fine a point on it, but really the international order in which we currently live. So I will add that to the mix, although I imagine that most of our discussion will be geared towards the physical cross-border threats, including, again, financial and other things. I don't want to lose sight of the information environment that is, to my mind, increasingly fragile.
Thank you, Carmen. And now I want to bring the conversation to Fernanda, because oftentimes when we have these discussions, we hear quite frequently, as Carmen mentioned, from the US perspective. So now I'm curious to hear, Fernanda, your experience having worked in this area in Brazil and the greatest cyber threats that your country is facing.
Okay, thank you. Thank you very much, Christopher, and everybody, for bringing me to the conversation, so we can give the Brazil's perspective in South America. Well, I don't work with cyber defense nor with cybersecurity. I'm a prosecutor, so I investigate and prosecute the cyber crimes. But as we could easily see last year, a cybercrime can very easily become a cyber threat to the national security. So for all these years, we've been having most the crimes: distribution of child pornography, frauds, electronic frauds, a lot of them, hate speech also. But then with the pandemic, our fears came true. We knew already that the environment of cybersecurity wasn't strong enough. And then it was mainly last year that the hacking attacks started, and I can say they exploded. So areas as health, all public institutions, it's crazy, but all public institutions almost were hacked last year. Ministry of Health, energy companies, also private companies, but the private companies, they keep a low profile. It's not on the press all the time because it brings bad reputation. But we saw, and it was very shocking to have a high superior court having to stop working for at least 10 days because everything was hacked, and they were threatened with ransomware. So fortunately, the data was recovered because it was stored in a server that was outside the system. But everything had to be stopped. No judgments, nothing could work. And then finally, the people and the government realized this environment has to have an enhanced security that passes through legislation, like Kimina said, to convince people and private companies and also the government that you have to invest in measures for gives security to the systems, and other legislation. For you to imagine, we already had some legislation on illegal access, but the penalties are ridiculous. So when we had this, all those huge attacks, even on infrastructure companies like energy, then everybody realized that even if we were able to catch the criminals, and in Brazil, and I believe in South America, the hackers are regional. You see, I don't see state-sponsored attacks, at least for now. But the hackers are national hackers, and they are really interested in getting money from the ransomware. So even if we were able to catch them, the penalties were so low that they wouldn't stay in prison. So it was really an awakening. And now we are having to rush to reform legislation and to go after the security measures to everybody. That's it.
And now we had gotten a question submitted in advance, specifically focusing on the changes in cyber threats to universities and colleges. So I was wondering, John, if you can comment on that, and then I would like to bring in Tara's perspective as well on that question.
Sure. So on the college and university side, the activity that we've seen often, at least again from the nation state perspective, and I think that there's criminal activity there too, but from the nation state perspective, has been about theft of intellectual property. So some of it widely indiscriminate. So we indicted a case against a set of Iranian hackers maybe 3 years ago at this point, the Mabna group. And they were, they had compromised professors' credentials, and then were using those credentials to just download the contents of libraries, everything you could find on different journals that were online, and it was kind of a steal first and then figure out what you need later approach to that kind of theft. Obviously, those subscription services and those sorts of things have a significant value. So that's one threat that we've seen. Another is much more targeted and focused on intellectual property that can either be monetized. So think, some biomedical research, things like that, or more, still targeted, but useful to a government in developing either militarily. So if you're a university that has classified contracts or export control contracts, especially with the U.S. government, or in the case of China, which has an intellectual property sort of, that takes intellectual property not just to develop the military, but also it's what we would consider its civilian economy, its private economy in our view, to take sort of cutting edge research in areas that are in their Made in China 2025 plan. And those are basically areas of technology where they want to lead the world by 2025. So, or have significant domestic capability in each of those areas by 2025. So those are the threats, I think that face the universities that we see from a nation state / sort of criminal perspective.
Sure. And Tara, do you want to jump in here as well?
This is a difficult one, because one of the places we find ourselves when in the cybersecurity industry, we make recommendations to colleges and universities. One of the biggest challenges we see is the heterogeneity of the responses from a student body. I'm thinking as an example today of looking at in the United States and in many other locations around the world, the tough choice colleges are having right at the moment about whether or not to require vaccinations before in-person classes or residence halls could open back up again. And on some level, it's not a question of whether or not to have that requirement put into place. It's whether or not you can get enough compliance from everyone in the student body, no matter which tack you take, in order to solve the problem. The challenge we see often with colleges and universities on cybersecurity is very similar, where it doesn't do any good to suggest that everyone use two-factor authentication. You need to mandate it all the way through. You can choose to not do so and use other perhaps less well advocated for and less appropriate security measures, but whatever you do, you have to go all the way with it. So the worst situation we can find ourselves in large institutions is to have recommendations that are never fully implemented and then are sort of abandoned in a cycle of recommendation and abandonment over years of trying to get a solution implemented in place. When I see colleges implementing two-factor authentication as a suggestion, I ask myself whether or not they're implementing those fixes and have appropriately allocated the resources necessary for education to get enough people to abide by it. Otherwise, your real option there is to mandate. So either choose the tactic that you want to take, choose the technical improvement you want to make and mandate it, or pick a different tactic. But don't make a bunch of different suggestions and hope that it works. At the same time, I do want to push back on John on the idea that there is kind of the massive theft of intellectual property coming from the students of those universities, especially after we look at the Aaron Swartz case and how the overzealous prosecution of someone who was looking to release knowledge into the world led to his eventual suicide. We see a lot of focus on this theft of intellectual property, when in reality, this is something that's available to anybody with the university login. I remember getting my university login for Harvard about a year ago and thinking to myself, I can finally get to all these articles and this sum of human knowledge. So on an idealistic front, I think it's right and appropriate for college students to want to try to make knowledge free. Sure, we have to be adults in the room every once in a while, but I don't want to see that idealism crushed in terms of making knowledge free to the world, making it available to people, especially in the global South, who do not have the money and capacity for those institutional subscriptions that we more fortunate folk have. So I do want to both note that our choices about how to protect people need to be consistent, if draconian at times, and also note that there is a place for that idealism, for keeping that knowledge flowing out into the world from those of us that find ourselves in this fortunate position, to bring it to everyone. Hope that works.
John, I was just going to go back to you to ask you I noticed you're unmuted, on how do you draw that line between combating what can be pernicious intellectual property theft? Like there was a discussion in the chat that Peter had mentioned about the theft of COVID-19 vaccine research versus the type of spreading knowledge and access to journals or other types of articles that Tara is talking about.
Thanks. So, I mean, I might have misspoke, Tara, but I certainly didn't mean to suggest. I don't think we've ever indicted a case that involved a student. We certainly haven't in the National Security Division that's involved a student who has tried to sort of open the portals of knowledge, using his or her login credentials or something like that. The cases I was talking about all have involved government actors, either members of the intelligence services of those countries or of the defense services of those countries, who were hacking into university systems in order to take intellectual property of professors or of the university they were doing the research. I agree with you. There is a distinction. I mean, it even struck me when we indicted it, the case of sort of, there is a distinction between sort of, I mean, you are still stealing, obviously, a subscription service when you take all that for free. There's no question about that. But that was a much less targeted and sort of like, I want access to your library approach than a lot of what we spent our time on the Chinese and Russian side, which has been more, I want access to this cutting edge research that, yes, will eventually be published, but their goal in getting access is to get ahead of where the researchers are at that institution in order to leapfrog them as a country and as individual researchers. And what we see, especially in China, is really an iterative process. And so if you take, for instance, aerospace jet engine development, we've had a number of cases that have involved the theft of intellectual property. And what we've seen is an iterative process between the intelligence services, the research universities in China who are doing aerospace research, and the companies in China that are commercializing that research, and sort of, the companies commercializing and saying, here's the problem, I need solutions. The researchers saying, here are the solutions we have to these problems. We don't have solutions to these. And then intelligence officers getting tasked to see if other countries, other researchers have solutions to those technical problems. Sometimes those solutions reside in university research, other times they're in the private sector. So that's really the problem that I have been focused on here.
Yeah, I think the case that Tara had been referring to earlier was a case out of the U.S. Attorney's Office for the District of Massachusetts. So I guess it's reassuring to see that, the NSD has made more of the distinction on this front. And I want to move along to the next question, or big area that I wanted to discuss, which is the topic of this panel, which is combating cyber attacks across borders. And we all know that this is no easy task. It can be difficult to identify the perpetrators. And then once we do find them, John, as you mentioned earlier, they may be located in countries that will not hand them over or meaningfully prosecute. So what really can we do to combat cross-border cyber attacks? And I guess, John, I'll start with you. And if you want to talk a little bit about the approach that the department has taken and championed in releasing indictments without hope of actually laying hands on the perpetrator, because oftentimes this approach has received criticism on a variety of fronts of showing that you'll never actually be able to arrest these people, yet the department has still championed it. So if you could talk a little bit about the rationale behind that and how you think that helps combat cross-border cyber attacks.
Sure. So, so first to place it in context, the prosecutions and our indictments and prosecutions are, just one tool in what we think should be the government's approach to combating malign cyber activity, be it criminal or nation state. It actually has, I think, more of a traditional deterrent impact on the criminal side. We have successfully indicted, extradited, and prosecuted a number of criminal cyber hackers. It's harder on the nation state side, and that's usually really what that criticism that you mentioned, Chris, gets directed at, is our nation state indictment. So that basically started, the first such indictment was in about 2014, when a set of People's Liberation Army officers from the PRC were indicted by actually some of my predecessors in NSD during the Obama administration, and that was a significant moment in the way the department approached these cases, and not just the department, but the government overall, because up to then we hadn't really indicted intelligence officers or army members, certainly, for that kind of criminal activity, who weren't here. We've always traditionally indicted spies who are here, even if they're working, obviously, when they're working for a foreign government, but folks who are outside the U.S. And in that case, and in many subsequent cases that have since covered, Russia, Iran, and North Korea, also, those defendants were not here. But the reason we do them is this. One, there's a lot of talk about how difficult attribution is in cyberspace. And the truth is, yes, it can be difficult, but it is also doable. And it's provable in a court beyond a reasonable doubt. And we will not indict a case that we don't believe we could prove using unclassified admissible evidence beyond a reasonable doubt. And so we think that our indictments in telling the story of the intrusion, whether it's the Russian hacking and dumping activity during the 2016 election, or it's Chinese theft of intellectual property, or it's Iranian or North Korean activity, in North Korean bank robbery, for instance, We think that that is a very convincing way for the government to lay out its proof and to show what it can learn and how to up to a point, right? Obviously, there's classified methods that sometimes we don't sort of fully disclose in those indictments of how we can show attribution. So that's one point. And then because I think, especially in the US system, indictments are a uniquely credible way for the government to speak because they ultimately have to hold up in court. They can be very powerful educational tools. Indictments also tell a story, which is a very important sort of rhetorical tool to use. I think it's very hard to talk about these issues in the abstract and, you know, use statistics and things like that. But if you can actually tell a story of a series of intrusions and explain the reasons for the intrusions and who are the main characters in this story, it's a way that really, I think, captures the public imagination, but not just the public imagination, but the imagination of the people who are being victimized by these intrusions. So the private sector or universities or state and local governments or whoever the victims may be, so that it then educates them, alerts them to an issue and educates them in a way that helps them then to work on that issue. And then in other cases, it's also enabled the use by other departments of their tools, whether they're sanctions or denied entity listings from the Commerce Department, their tools to try to just be another part of this toolbox of activity to fight against cyber intrusions. And then finally, I'd say, you know, so we've continued to do that then in the years since 2014. And I think through that, as I said, I mean, I do think the indictments that the Mueller team used and that we used having to do with the Russian election interference helped tell the story of what the Russians did in 2016 and helped frame it in a traditional criminal context that I think folks could understand. You know, and then, but in addition, what we've been trying to do is ask ourselves, and in fact have used other criminal tools to try to disrupt these intrusions. So most recently, I think we announced that we had used a criminal search warrant to remove some of the web shells off the, you know, the servers that have been infected during one of the Microsoft hacks, which is known, I think, commonly. We've never attributed it, but as the Hafnium hack. You know, another thing we've done is use a search warrant to create sinkholes, right, to redirect malware and botnets. Another thing we've done is use warrants to map botnets so that we could learn who the victims were and alert the victims that they had been infected. So what we're trying to do, and I think you're going to see this more and more as the department continues to emphasize cybersecurity in the current administration, is the creative use of our criminal tools to disrupt cyber activity that may be sort of on the way to having an indictment, or may be activity that we never get to an indictment, but we still think we have a value to add working with our partners at the FBI in disrupting that activity. And of course, you know, maybe most famously, recently the FBI's seizure using a civil seizure order of the proceeds of the recent ransomware attack.
So I want to bring in Shemin now, because I know you've written an article on this very topic of attribution by indictment. And I also would like you to comment a little bit. I know you and I had discussed this previously a few weeks ago about the question of actually indicting state actors and what the implications of that are under international law, specifically related to the other area that you work in, which is on foreign immunities.
Well,
it's a
so
big
that I don't go on for 2 hours, right? Yes. We'll do the Cliff Notes version of some thoughts, and I actually took the liberty of dropping the link to that really short article in the chat for anyone who's interested, mostly as a source of citations to some of the indictments that John mentioned, because they are so carefully and laboriously crafted to tell very important stories. I think taking a step back and looking at the legal framework, right? I think so maybe 2 or 3 points to clarify, especially since I would imagine many of the people on this call aren't lawyers, at least for your sake. I hope that you're not. We're dealing with at least 2 distinct bodies of law here, right? We're dealing with any given country's domestic law. which will certainly govern conduct on its territory and will likely govern conduct with a direct effect on its territory. And those are the laws, of course, that our Department of Justice is charged with enforcing. Fernanda in Brazil, of course, is enforcing Brazilian laws. She told us earlier that some of them are now being modified to give people like her sort of greater ability to actually attach consequences to the activity that she's discovering and indicting. So these are domestic law indictments, but as everyone has mentioned, particularly because of the intangible nature of cyber, many of these indictments lead us across international borders. And so invariably, we're also going to come up against foreign law, so the domestic law of other countries, and we're going to come up against a big limitation on the investigating country's ability to operate outside its own borders, limits on what we call enforcement jurisdiction, right? So we need to work cooperatively. And some of these cooperative instruments probably come under the rubric of Fernanda's master's degree, right? Transnational law. We've come up with this sort of additional category that's kind of a hybrid of domestic and international law. The purely public international law, right? The stuff that I dealt with at the State Department, has traditionally governed more of the, what Tara referred to as the act of war side of things. And one of the pieces that I wrote that you mentioned in those voluminous intros, Christopher, is co-authored with Mika Oyang, who's now Deputy Assistant Secretary of Defense for Cyber. And we try to kind of put things on a continuum, because I think what the challenge that we're all encountering is that it's very difficult to put this activity into silos, right? So John has already talked about, well, NSD needs to work with the FBI. Some of these cases might be prosecuted if they involve state actors by the National Security Division. Others would be traditionally handled just by the criminal division, even within one agency. And then we go beyond that agency, dealing with things like mutual legal assistance, where we might need to get the State Department involved, because we'll need to rely on an international treaty that gives prosecutors in our country the ability to do things, whether it's request the extradition of suspects from another country, whether it's request the surrender of evidence. And of course, in the cyber realm, we're now dealing with additional treaties like the bilateral US-UK treaty that affects fundamentally not only sort of data privacy across borders, but also investigative capacity of state and local and federal law enforcement to obtain evidence that may be located overseas. So the cross-cutting nature of these threats poses not only a resources challenge, but also a tremendous bureaucratic challenge in just figuring out how to parse all the different pieces. So the additional layer that you mentioned only further complicates the issue, which is that in international law, we have a principle of sovereign immunity, right? And so let's, it plays out a bit differently, at least in the US, on the criminal side and the civil side. So that's a whole other discussion. But on the criminal side, as you noticed, for example, with the indictment of the Internet Research Agency, for example, it was not an indictment that was nominally against the country of Russia, right? We don't normally think about indicting countries themselves. And so then when you indict individuals or entities that are closely associated with countries, the question inevitably arises, is there an international law rule, right, of sovereign immunity that would make that inappropriate, that would give the foreign country or the foreign defendant a basis for arguing that actually, no, they're beyond the limits of our domestic criminal justice system. And the reason that that's, I think, important to take into account, and I think the Department of Justice has, you heard John earlier, trying to parse very carefully what we might consider intellectual property theft for military purposes versus sort of intellectual property theft, even perhaps by some of the same actors, but for what we would deem commercial or private purposes. of course, complicated by the fact that China does not really make that distinction, right, either functionally or conceptually between private and state action. We've, at least my observation is, that we've been trying hard to stay on what we characterize as the private or commercial side of things, in part so that we don't run afoul of that immunity norm, and importantly, so that we don't inadvertently expose, our cyber actors of various sorts to reciprocal indictment and prosecution. Although that concern, and I've discussed this with friends and colleagues in the department, may be more theoretical than real, in the sense that the places that would probably seek to indict US cyber actors are not ones with whom we have extradition agreements and so forth. So, so the multi-layered aspect of this, I think, is one of the reasons that, well, number one, it's a great topic to launch this Tech and Society conversation series that Rhodes House is convening, but also why it really requires conversations among folks who might not usually talk to each other.
And another important consideration as we think about combating cross-border cyber attacks are the implications for human rights and data privacy. So I want to turn it over now to Fernanda, especially since you've worked in the Human Rights Unit in Sao Paulo, talk about how you as a prosecutor balance these considerations of data privacy and human rights while still trying to bring cyber criminals to justice.
Okay, thank you. First of all, I'd like also to put light on the fact that one of the reforms we are doing is to join the Budapest Convention, which is the international agreement on cybercrime. And it is based on the respect of human rights and privacy and all the liberties. So it's really a very important thing to say here. And well, that's it. When you investigate and prosecute cybercrime, it's inevitable to need international cooperation. As I have already said many times, in Brazil, we have national legislation, which gives us the ability to have data from the companies that are providing services in our country to the people in our country. So for some time, we didn't need so much the international cooperation. We were putting the MLAs aside, but then the most sophisticated criminals, they realized that the companies in Brazil were complying with the justice. Many, some of them are not yet, but they are adjusting. But the majority of them now has turned to international services that are beyond our reach, so we can't reach them. And well, both when you ask for cooperation or inside, when you at the national level, when you are going to ask for a search warrant, you are going to you have to violate a right to get data. You have to balance, to make the balance, look at the proportionality. You have to look at the seriousness of the crime and how much you are intruding on the person's intimacy and how much you are intruding the rights of the person. So I'll give an example, a very simple example: child pornography distribution, which is one of the most great crime that is very, very, we have lots of this in Brazil. Each image of child pornography distribution represents a real violation of a child. So it's really, really serious. But then you have to balance it with, if you have consistent evidence, if this one picture is enough for you to enter the house of a person or getting all the data of the person. For instance, nowadays, you get the data mostly from the mobile phone, where the life of the people are there, all the communications. And then you see in Brazil, you can see the jurisprudence changing. In the beginning, you could catch the mobile phone and look at everything. Then now, as we have the messengers and the mobile phones, the jurisprudence that doesn't allow you anymore to look at the communication. They say, no, it's too much intrusion. You have to ask for another warrant, and the judge will have to justify why this violation of the intimacy is being granted for the amount of data you need to solve a crime that is really important, really serious. And that's the same at international level. So I believe that in the Budapest Convention and also in the additional protocol that is being prepared, all these issues are being tackled, and all the member states have to do this balance. Otherwise, the cooperation can be refused.
Now, Tara, I want to bring in your perspectives on this because you've worked as an advisory member with the Electronic Frontier Foundation, which is very much concerned about data privacy. And building off of the points Fernando raised about this balancing act, one of the things I've heard in my own research from law enforcement officials is that they actually feel hamstrung by data privacy rules. And they say, well, yes, obviously there's a threat to data privacy from the government, but then also cyber criminals, when they get access to data, that threatens privacy of itself. So it's not really an either or dichotomy. So I'm curious how you think through and how you've advised organizations on thinking through these questions.
Well, there's a good way to think about it, which is that I think last year the FBI successfully prosecuted something like 230 cases involving encrypted phones, and was successfully able to get the data off of them, and at the same time is claiming that they have no access to these phones and that there's a going dark problem. I think one of the challenges here, and as a person who is very clearly on one side of this debate, because it is a debate, technology is inherently political. This question of whether or not we need to be able to guarantee private communications goes to one of the most fundamental human rights imaginable, which is the freedom to have your own thoughts, to think the way that you wish, to have private conversations with people, and to not engage in the public sphere if you do not wish to. Now, one of the problems we're having is technology is jumping along so fast that on a lot of different levels, a phone is not the same thing as an intentional letter being written to someone else that can be intercepted and read. On a lot of levels, a phone is an exocortex at this point. It's your brain outside your brain, and there's a big difference between a communication that's intended to go someplace and something that's intended to store information from inside your mind. The world of jurisprudence has long recognized a difference between a letter that's intended to be sent to someone else and someone's personal diaries or journals, right? And on a lot of levels, we are moving technology so fast that unless we make good law now about the privacy and immutable right of each person to communicate and to have that freedom of expression, we're getting close to a question of whether or not we are okay with mind reading, with using unconscious behavioral analytics to determine what someone is thinking and how they're going to act. And that kind of information is going to show up first on people's phones. Now, on a larger question about how data privacy works in the corporate information security industry, then I'm gonna put my Silicon Valley hat on and tell you that if you are provided a phone by your employer owns that phone and has the right to do whatever they wish with it. It is their property. Communications you engage in on that phone belong to your employer. And I have frankly, less sympathy for people who wish to maintain data privacy on a device owned by their employer. This is one of those places where I strongly think that if a person wishes to have that kind of privacy outside of work, they need to keep their exocortex away from their company servers. So there's two different sides to this. There's the fundamental human rights aspect of it, where yes, criminals do in fact engage in freedom of expression, and the world in innovating is going to innovate not just for good people, but bad people at the exact same time. And I am more interested in protecting the rights and freedoms of human beings that have not yet committed crimes than in attempting to proactively punish people who have already done so. So when I look at the question of data privacy overall, I try to balance it, as it is a balancing act between whether or not we are protecting the rights of human beings, fundamental rights to communicate, maintain privacy, be able to express themselves, engage in political speech without fear of harassment or surveillance. And at the same time, acknowledging that on a corporate level, I don't believe that a person who is using their company provided phone and company provided apps on a company dollar to engage in things they would like to have kept private, I don't believe that that right exists for them in that moment. They have used someone else's property in that situation. So I can comfortably live in both of those places, and it depends on whether or not I'm talking to the EFF or if I'm talking to a publicly traded corporation as to what technical elements I want to engage in, I want to advise. I've been the person who spun up the technical data privacy practice at a large security company before, and the most important thing to think about with data privacy on a technical level is approaching those business lines at an orthogonal angle, at a 90-degree angle. So I'm being redundant with my geometry here, but the idea in technical terms is think about it sideways. On human terms, protect the rights of people to engage in private and protected communication and speech, and recognize that for all that law enforcement frankly is claiming that they don't have the ability to get into phones, to get to this information, prosecutions are proceeding apace and speeding up. Seems like they're doing fine on a lot of it, especially after the recent anom break of news by the FBI, who've been apparently running a massive communications app and phone ring for years, and just took down something, like 700 computer criminals and child porn addicts. And that seems like a wonderful use of technology to me. If you're going to use somebody else's technology, don't be surprised at what happens with it. So data privacy is a complex issue. It is political, but the technical elements of data privacy aren't going to change. There's no way to kind of a little bit break encryption. In the same kind of way that you can't, for those of us who enjoy 1984 and maybe the Chain of Command episode of Star Trek: The Next Generation from the sixth season of it, and we either hear Winston saying there are 4 fingers or Captain Picard saying there are 4 lights. This is the equivalent of the opponent saying, I want to compromise with you. I understand I think there are 5 and you think there are 4. All I need you to do is just tell me there are 4.5 lights, and then we can reach a compromise. Math doesn't work that way. Truth doesn't work that way. But the politics of data privacy are going to continue to need to be balanced depending on ownership and context for a long period of time. But start by telling the truth always about what math can and can't do. You can't have a little bit of encryption.
I'm going to have to restrain myself because I could have a whole list of questions I could go on from here, but I did promise that we'd leave about a half an hour for audience questions. And I'm going to just start off with one that was pre-submitted. And Tara, I'll go with you again. Sorry to have you have back-to-back questions. But this was from a 1982 Rhodes Scholar, John Board. And he notes that some, including the US Energy Secretary, have suggested that ransomware payments by victims should be criminalized or otherwise banned in an effort to stifle the original criminals. So I'm curious what your thoughts would be on this, and you can feel free to comment more broadly on how to better promote that cooperation between law enforcement and industry when their incentives may not be always aligned.
Incentives is the key word there, and thanks for the question. It's incentives that are exactly the issue. This is an ongoing issue, the question of whether to ban ransomware payments. And as I was saying to somebody else this morning, right now, ransomware and the question of whether to ban those payments is complex because there are multiple different sliders that we can use to control whether or not this is going to keep happening and get worse. Right now, ransomware payments are getting worse because governments are getting the incentives wrong. The FBI right now is saying, don't pay ransoms. The IRS is saying, here's the place where you can write ransomware payments off on your taxes to businesses. I don't think if you paired 2 incentives of law enforcement saying no and money saying yes, you could find a better way to screw up incentives for companies. And part of the reason why is This kind of thing is the kind of thing that will always hit small to medium-sized companies worse than larger companies that can afford fundamentally what's going to be a tax on paying those ransomware payments. It's not going to get criminalized. There will be a fine or a penalty for it, but in the United States, I find it difficult to imagine that there's going to be a lot of white-collar executives hauled off to jail for paying ransomware payments to try to keep trucks on the road and hospitals stocked up. So it's going to be a fine. And if it's a fine, what we have there is a law that only applies to poor people. So banning ransomware payments is a complex issue, but we need to get our incentives correct before we ban them. I'm not saying don't do it, but I am saying that the incentives must be appropriate and aligned for small and medium-sized businesses to be as successful as large businesses in fending off these criminals, because it is unforgivable what they are doing to critical infrastructure, small healthcare organizations, to people that have no idea what's coming down the pike at them. It's unforgivable. And yet we're not seeing a coordinated government response yet. For any of those folks out there who've ever flown a plane or ridden a motorcycle, you know that your movements must be coordinated in order for them to be effective. If you have an uncoordinated action that you take, you skid out or you crash instead of actually achieving the objective you're going for. This is one of those moments where we need to get back in alignment and make sure that we have a coordinated response when it comes to banning ransomware payments, or we're just going to see the problem get worse and law enforcement get ignored about it.
Before I turn this over to John, because I'd be curious to hear his thoughts on this, Tara, you had a follow-up question in the chat about what about better education regarding that paying ransom doesn't mean you actually get your data back. And I'm curious, the audience is curious what your thoughts on the role of that better education can play in combating this threat.
Do you want John to talk first or me to talk first?
Tara, if you want to just answer that quick follow-up, and then I'll go to John to respond to the broader question.
Education's not going to do any good. People who are panicked and frightened are going to do whatever they think is necessary in an existential crisis for their company. They're going to do what they get told to do. And so it's important to educate them not on whether or not they're going to get their code back, but precisely where at CISA you report this kind of attack. By the way, it's cisa.gov/contact-us. I have it memorized. Ask me how. And that's the answer is tell them where to go to get help. Don't tell them how to make better decisions on their own. This is not something that can be done on an individual basis. Only a coordinated approach to the problem of ransomware is going to end up working. This is not one of those moments where you can soldier on through this problem alone anymore. This is a national security issue. We don't tell individual people, head to the border with a gun and stand to post for your country. We've got an organization that handles that, and it's time to be more organized about it. Education doesn't help people in that situation. We just need to tell them where to go to ask for help when it's available to them. Please.
So John, if you want to jump in now on the question of criminalizing ransomware payments, and if you have broader thoughts as well on improving that relationship between business and government.
Yeah, sure. So, I mean, look, I certainly agree with Tara on the need for the business community and the government to work better together, for the business community to reach out to the government. And that includes when they're paying ransomware and providing some of the information in the same way that if somebody kidnapped your dog and was asking you to pay ransom, hopefully you would call the police and tell them where you're going to drop the money if that was your intention to drop the money. I'm not, on the question of criminalizing ransomware, I'm not there yet. I don't think the government is there at this point. It's, we haven't in the past criminalized people who paid extortion money. If somebody came up to you and said, hey, I'm going to burn down your business, well, it's a really pretty pizza shop you have there. I would hate for anything to happen to it. And you paid protection money. We don't generally go after the victim of the extortion scheme and charge them. So I'm not really there on the criminalizing ransomware piece. I do think that I agree with Tara that the incentive structures even in the government are mixed right now, although the official government advice is make your own decision, but we don't think you should do this. But I should say it is joined now with, but if you're going to do it, involve us in that process to some extent. Obviously, we're not making the payments or anything like that, but And it is the kind of collaboration that we're going to need more and more. I have to say that one thing that we were worried about, you know, when we did do the Bitcoin wallet takedown, you know, we didn't want to create a moral hazard that, you know, folks thought, well, that's great, I could pay my ransom and then the government will go get it for me and give it right back, and I'll have my data and I'll have my money. You know, it is not something that is replicable in every case. You know, it's important for us to message it that way, but it is something, again, a tool that we can use in the appropriate circumstances to disrupt some of this ransomware activity. So, you know, at the end of the day, you know, what you're seeing right now from the White House across the agencies is a lot of focus on what government could be doing more with business, on how we collaborate on these issues, but I don't see a lot of appetite for criminalizing ransomware payments.
I'm going to go now to another question that was submitted a little bit earlier in the discussion in the chat, and I'll start with Fernanda. And you have talked a little bit about some of these issues in terms of the penalties, but the question reads, given the legal strength of the panel, what are the upcoming challenges to the legal systems around the world which need to be addressed by new legislation, new systems and processes, training for legal professionals and legislators? Ideally, the questioner would be interested in a look over the horizon beyond those things that we know we should do but haven't gotten around to doing yet, and to get to what is coming next. So kind of what are the future legal challenges that you see for countries around the world in order to better address cybercrime? Like, what do they need to be, you know, 5, 10 years from now?
Yes, as cybercrime is a global crime, and everybody in the planet is being affected by it. Even when we say about Russia, Russian citizens are already being targeted with many cybercrimes. So I believe, and in the other countries too. So I believe the cooperation is an issue that will have to grow among all the countries as far as it possible, as it will be possible, because cooperation means to have an effective cooperation, you have to have trust among the countries. And I know we don't trust everybody. So, but considering legislation, the biggest challenge to have an effective legislation is to have to harmonize it, because if everybody considers the same serious conduct a crime, and if it's written in a way that everybody recognizes it as that conduct, so it's easier to get cooperation from one another's. I think this is, in terms of legislation, this is the great challenge, to bring as many as countries as possible to the cooperation field and harmonize the legislation.
And Shaman, I'd be keen to get your thoughts on this question as well. And perhaps you might be able to comment a little bit on the new proposals for a UN cybercrime treaty that have come out recently, and your thoughts on how that fits into the process. I keep giving these questions that open Pandora's box, so I apologize, but.
Again, this is all a beginning, not an end, to discussing these issues, right? And I think, you know, and Tara put in the chat, and as Fernanda was saying, you know, international cooperation is the sine qua non of dealing with these things, right? So we have decisions, each country has decisions to make on a domestic level, right? Just as each country may have different definitions of crime when it comes to incitement, or even when it comes to something like pornography, or, you know, different penalties, different ideas about sentencing, different ideas about the trade-offs that Tara described between you know, personal privacy and law enforcement's ability to access information, again, even without crossing a border. So there's some fundamental core of values, right, that each country is going to need to decide for itself. And then beyond that, as Fernanda says, there need to be cooperative mechanisms. And as she mentioned earlier, you know, in this context, right, and in sort of the transnational law enforcement cooperation context, this Budapest Convention, which was, you know, really revolutionary at the time, but has now been with us for a while, is where the core cooperation has been, and it is not inclusive of a number of states where a lot of this activity emanates from. So the idea that there might be a subsequent or a new convention on cybercrime, I think is driven by this, the recognition that we need to have a more inclusive framework that brings in, the countries that are the most problematic in this area, and China and Russia being two of them, although certainly not the only two, and each of those being problematic for different reasons. The big concern is that bringing those countries on board, in a sense, gives them both the platform and the opportunity to then write the rules. And so there's been a lot of concern, especially in the human rights community, but also more broadly among Western liberal democracies about the potential use of a new treaty as a weapon for repressing domestic dissent, pursuing political opponents, and so on and so forth, because, as is probably quite evident, and some of the comments already made, highlight the same tools that are used to prosecute crime that we would all agree, fraud, theft, the rest of it is pernicious and needs to be stopped. Those same tools can be used to pursue, to harass, political dissidents and people on, political opponents, you name it. And so again, this is a problem that every country has had to deal with domestically for years, as these forms of crime become more transnational in nature. I don't think we're going to get to a global values consensus were such a thing even possible. And so the real trick, as is the case in most international negotiations, right, is to find a kind of modus vivendi for sufficient cooperation to keep these kind of attacks, and I'm using attacks here obviously in sort of a colloquial sense, not a technical legal sense, these kind of activities, right, malicious activities, to a manageable level, without, opening. So you use the term Pandora's box in another sense, but I'll use it here, without opening the Pandora's box of facilitating repression. And the one maybe note of comfort that I can sound, if it is that dynamic is not new, right? That dynamic is the dynamic that we encounter in virtually every international negotiation, whether it's, whether we're talking about nuclear arms control, or whether we're talking about hostage taking or airplane hijacking or drug trafficking. So, there are the tools to at least put in place these kinds of frameworks exist, but where we're going to land on them, I think, is still to be seen. And I guess the one other thing I'll mention, although again it's sort of more big picture, is, as many of you know, with the advent of 5G technology, there are big questions that have been raised about, is that the promise of the global internet, right? This sort of free flow of information across borders, which is already, right, not so much a reality. We have firewalls and the rest of it. Are we going to be able to realize that, or are we going to end up with what people call it the splinter net, or whatever you want, much more fragmented system, precisely because we can't get that kind of legal coordination? Because I am not a technical person, but all of the technical aspects that Tara has evoked here, you need to have, they need to correspond to the legal mechanisms. At the moment, there's just a lack of correspondence, right? We've got a global reach of these technologies and a fragmented and disjunctive legal regime. So either the legal regime is going to need to catch up to the technology, or what might happen is what we're starting to see a bit of already, is that the technology will fragment, and we will just have environments in which certain actors agree to cooperate, and then other environments that are kind of outside of that sphere. And the problem with that, of course, is that you can't sort of hermetically seal the country from cyber threats emanating from other places. Maybe you could do it a little bit on a technical level, with these kind of so-called firewalls, or not having undersea cables that actually connect, and so on and so forth. But there's going to be a fundamental choice that I guess my advice would be to try to make it deliberately, rather than just realize 10, 20 years from now that we've ended up in a certain place, about literally how connected we are all going to be to each other, and what the implications of that are.
And now I see that Mervyn Frost has raised his hand, so the floor is yours. Feel free to unmute yourself and pose your question to the panel.
Thank you very much to all the speakers. I found it absolutely fascinating. This is an extraordinary moment, I think, in world history. And I just wanted to, as it were, ask a question, building on the points raised by both Fernando and Ximena about this. These problems can't be solved in single countries. There has to be international cooperation. And we've had, in other domains, we've had enormous success on international law, on trade, on finance, on telecommunications, on posts and telegraphs, on air traffic control, and so on. And so it would seem to me that the common interest of most states would be moving towards some kind of international regime. And so I just would like the panelists to make some comments about where we are now. There is that convention that we already have, but which clearly is not working very well. Where are we politically? I mean, is there nearly a consensus amongst most states with the 4 outliers that were mentioned, or are we miles away from any kind of agreement on this? Thanks.
So I noticed that we're also running slightly short on time. So I think if we do this as a lightning round among each of the 4 panels, that's probably the best way. I mean, if you could each talk for about a minute or 2 of your thoughts on this question. We'll start with John, since Fernando and Ximena had talked about this previously, and go to Tara, and then Fernando and Ximena again.
Sure. So look, on a tactical law enforcement and intelligence level, there is a tremendous amount of cooperation occurring now. Certainly we cooperate very closely, especially with European partners, with the partners in the Pacific, on all of these cases, because none of these groups are targeting just one country's companies or one country's people. But I have to say that, the difference, and Ximena is right, so you have technology, then you have the law, but the law reflects values of the people and of the nation. And the difference ultimately is in those values, and ultimately, what worries me and a lot of others, including the human rights community, that Shreya said about entering into a new set of negotiations over a new cyber treaty, is that the human rights and democratic values that we would want to have protected in a free and open internet are not those that other big players in this discussion are bringing to are going to bring to the table. And so it may be kind of an impossible task, as much as we would love to have a global framework for this. That might just be very, very difficult. That said, I have to say, the problem is, you're right, most of the world is there, but some of the folks who are not there are really big players in this area. And so that makes it a real challenge.
Awesome. Tara?
Professor Frost, it's an honor. Thank you so much for the question. I would love to just say, first of all, that when it comes to the realm of international regulation and norms, I was in a similar conversation to this at Harvard's Belfer Center, and Joe Nye asked a similar question. Does it make sense to have these international regulations and norms if no one's going to follow them? And after saying, thank you, Professor Nye, for proving to me that I can still feel stage fright, I said, just because we know that there will be people who defect from these norms doesn't mean they're not serving a purpose. Sometimes simply having this regulatory climate, having these agreements, and having these norms helps us identify people who are willing to break them. And when we've identified people who wish to stay within the international order and those who are fine defecting from it, we've let those norms serve a purpose, if only for the purposes of identification. It's not perfect, but it does help to label appropriately. And as far as the second part, do we have these conventions? Are we abiding by them? The biggest challenge I face on an everyday basis is figuring out how to use a 2-syllable word for things other people are using 5-syllable words to describe. It's really common in cybersecurity for people to think of computers as being somehow magical. We already have names for these crimes, as I've said before, and while we already have a digital Geneva Convention, we already know what fraud looks like, we already know what war looks like. I think we have a vast gap in communications and an unwillingness on the part of many of the people who were influential in the situation to acknowledge that they don't understand how computers are being used in modern warfare, and that they are. And I think it's going to take not only something of a heroic uplift in education on the parts of the people making these laws, but also a willingness for people coming from my industry to communicate in terms that are intelligible to policymakers as well as people with purchasing power at information security conferences.
Awesome. And Fernanda, if you want to weigh in on this question.
Yes, of course, great. What I believe about the UN Convention is that it will never be so detailed as the Budapest Convention, because, as I said before, the Budapest Convention has principles and rules that make the cooperation effective, but they presuppose that the states have trust in each other, and at this level, at this moment, at least, maybe utopically, one day all the countries will trust each other at this level. So what I think about the UN text is that we'll reach we'll have general rules of cooperation, what will be good, and at least we'll have points of contact. We'll have a channel to address in need of cooperation. For instance, recently, we needed some information about a Russian email. We didn't have any channel to reach the Russians. We would have to go through diplomatic channels. So in the electronic evidence world, we had to abandon this lead. We wouldn't have it in time. But I think it's good to have this general principles, and but it won't be like Budapest Convention, because the countries have different views on internet, as Kimena has said. The view on internet is different, so we won't reach that level of trust. But for those countries that are on the Budapest Convention, it will be great, also because of the additional protocol that is going to update the rules and bring more effectiveness to cooperation. And even to some countries that won't join the Budapest Convention, maybe for political issues, maybe because they don't know it, they haven't read it. It can be how can I say, it can be I don't remember how to say it, but it can be a parameter. We can use, we can have cooperation based on reciprocity, based on the principles of Budapest Convention, you know, so that's the importance of it. And the UN, I know it will be a difficult path, because maybe the countries with different views will try to impose their own views on internet, but fortunately, the recent decision that all the rules that will be written will have to obey 2/3 majority. It means a qualified majority, and only after the consensus has not been reached. I believe this is a real important issue to guarantee the convention will stay with the human rights. Okay, that's it.
And Shaman, as our resident international law expert, I'll let you have the final word before I close off our discussion this evening.
Well, yeah, thank you so much. And I think, you know, Fernanda is actually doing these things, so I'll let her have the mantle of expert here. But look, I mean, yes, Professor Frost, you've taken me back to my Oxford days, right? This is the classic and the perennial question of, you know, which functional areas are best suited to fairly frictionless international coordination and cooperation, with the sort of additional layer of voluntary acceptance of legal obligation on top of it, and which ones are trickier. And we've muddled our way through in the last 70 years, I suppose, during the period that we've had the United Nations in sort of more deeper and more detailed cooperation in a range of areas that has, more or less held up. When you mention aviation, of course, I think of the recent, forced landing of a passenger plane in Belarus. And so we're starting to see even more challenges to some of those things we once took for granted. But I think that the basic point that Fernanda and others have made, that the US, China, and Russia are not on the same page. Many other countries are getting closer to the same page, and the glass half full version is we're all still talking. The glass half empty version is we're never going to agree completely. And the question mark is, can we find a modus vivendi in which, just to put it starkly, Russia's, the benefit that Russia gets, just to pick one of them, from continuing to let its hackers do what they want off hours and then, turn them into troll factories on other times of the day, when those benefits outweigh the burdens that Russia feels, then Russia will keep doing that. And if at some point, whether it's prosecution, sanctions, you name it, they feel, or maybe as Fernanda said, a domestic pressure because those hackers are also targeting Russian citizens, even though they're supposed to be off limits from what I understand, then behavior will change. And then we can sort of crystallize those norms of behavior and formalize them in legal instruments that will then hopefully also have some stickiness to them when the incentives become looser. But Christopher, I'll pass it to you. Thank you for wonderful questions, wonderful comments. And as with all of these topics, I'm sure we could easily stay here all day.
Yes, definitely. I was just thinking it leaves so many questions unanswered, but I think that is the core of the challenge of cybercrime, of how many complex challenges there are to solve this issue. And I want to thank everyone for joining us today for this conversation. Hopefully this has raised quite a few questions in your head and you'll be inspired to read some of the articles that Shemin and Tara and others have alluded to and posted in the chat. And I would really like to also thank our incredible panel, John, Fernanda, Shemin, Tara, for taking your time to join us today and share your insights and your wealth of experience and give us all more things to think about in this area.
So thank you so much for giving me the opportunity to hear you, because there are so many interesting points of views and new information. Thank you very much. Great panel. Congratulations, Christopher.
Thank you.
Thanks so much, all.